Good afternoon, everyone. My name is Bill Ferrigno, and I am the chairman of the HBRA Connecticut Developers Forum. We're happy all of you are on the line with us. This afternoon we have like an exciting presentation. Well, I don't know if it's exciting, Tim, but we have an important presentation
Important.
from an old friend of ours and supporter of our association, Tim Hollister, who's a partner at Hinckley Allen, and alongside of him, helping him with today's events are Andrea Gomes, also from Hinckley Allen. And we also have Leah Rubega. Did I do it that way? I did it the right way. Okay. So all of these are legal experts. They're all friends of our industry, and they're here today to talk about specifically some revisions to Connecticut land use bill that recently got signed, I believe, by the governor. So this is part of a series of events that we've been doing statewide. Some of them Tim has been involved in, and others are live events we do at the Developers Forum. So we got a lot of area to cover, so I'm going to turn it over immediately to Tim. Welcome, Tim. Thank you.
Thank you. Thank you, Bill. I hope everybody can hear me and see me. Yeah, there we go. Thanks to the HBRA, Jim, Joanne, Eric, and Sheila. Thanks to all of you, including Jim Paris, who worked on and shaped the legislative bills that we're going to talk about today. And thank you to my colleagues, Andrea Gomes and Leah Rubega, who are seasoned land use lawyers here at Hinckley Allen. I'm very blessed to have a deep and experienced team here. And as you'll see from the presentations that they will make after mine, we're going to talk for about 45 minutes. And if you want to submit a question, use the Q&A function on the bottom of your screen. We will have the slides available after the presentation, and as well as a recording of our remarks. So we're going to talk about three topics today. And the first one is, for the first time in a generation, we have real change in statewide land use laws. The bill is called the Desegregate Connecticut Bill, but despite its title, it's really about sort of bread and butter land use rules and some pretty substantial changes, as I will explain. Second, we're going to talk about the legislature's extension of the duration of most site plans, wetlands permits, subdivision approvals, and special permits and special exceptions, with a very confusing twist, courtesy of the Connecticut Appellate Court, and a further confusing twist based on what the governor did, an additional law that he signed on Monday. So it's been a very exciting 3 days here, and we're going to share the results of our, Andrea will share the results of our excitement with you. And then finally, and certainly not least, Leah is going to cover the new rules for public hearings and meetings post-pandemic, which is a combination of, we're going back to the pre-pandemic rules in some cases, but we have new rules in place because the governor's orders on the pandemic rules expired June 30th. So there are traps for the unwary all over the place, and Lee is going to walk you through that. So Andrea, if you could go to the second and third slides, that'd be great.
Yep.
Okay, there's your coverage and there's your presenters, and we go to the next slide. Okay, so the main event this year was called House Bill 6107, which, by the way, had a 24-hour public hearing in front of the Planning and Development Committee. It became Public Act 2129. To summarize 100 years in about 60 seconds, Connecticut's land use laws were formulated in the 1920s, and when that happened, they were very explicitly, one of the main purposes was to enforce and maintain racial and economic segregation. Now, over the years, the worst practices like explicitly racial covenants in subdivisions have been outlawed, and we have, since the 1960s, the fair housing laws, which are intended to prohibit discrimination in the availability of housing. But the basic structure of zoning in Connecticut really has not changed very much in 100 years, and that has four parts. The legislature has given broad authority to municipalities to enact land use regulations and grant or deny permits. It's administered by 169 separate towns. In privately, the land use lawyers call them fiefdoms. And it's largely by untrained volunteers And with some exceptions, such as 830G, the courts are directed to defer to local discretion. So all this creates a bias toward preserving the status quo, which is why today Connecticut is recognized as the most racially and economically segregated state in the country. Okay, fast forward to spring of 2020. The death of George Floyd, the rejuvenation of the Black Lives Matter movement, a group called Desegregate Connecticut, led by University of Connecticut law professor Sarah Bronin, came together and asked, is this the time finally to start dismantling some of the worst practices that we find in our current zoning legislation? So she pulled together, and to her credit, a coalition of organizations, research webinars, and at the end of last year, they put together a draft bill. Now, the reality is that a lot of their proposals were deleted, stripped out during the legislative process, but there is no doubt that what came out at the end and what is now going to be law in October of 2021 is real change, and that's what I'm going to talk about. And I will tell you, when I talk about these various provisions, keep in mind that the goal here was to dismantle what promotes and maintains segregation and exclusion. So it's enable best practices, prohibit exclusionary practices, and encourage more change, including regionalism. Okay, next slide. Now, sort of a really good example of how the title of the bill really doesn't really explain what this is all about is this, in my opinion, is the single most important change in the bill affecting land use. Mandatory limits on parking spaces. You may say, wait, what? Here's what happened. This is backed by actual research on usage, and note that Professor Bronin was for several years the chair of the City of Hartford's Zoning Commission, which, among other things, has banned any parking requirements in the downtown area. There's just no parking requirements if you want to do a development in downtown Hartford. So anyway, the new bill, effective October 21, says unless the zoning commission and the town opt out, and I'll explain what that means, the maximum that the zoning regulations can require is 1.0 spaces for an efficiency or a one-bedroom unit, and no more than 2 spaces for a unit with 2, 3, or more bedrooms. So the opt-out process is very intentionally difficult. It has to be a 2/3 vote of the zoning commission and the town's legislative body. I think frankly, that there are going to be very few towns that are going to opt out. And if they do, they're going to really have to have a good reason. So this is immediate, substantial statewide revision of development standards. Put in another way, you're now going to get more room to develop on the parcels that you own or have control of. So I think this is a big deal. Next slide, please. So the next, which goes hand in hand, is a ban on non-occupancy based minimum floor area regulations that exceed the state health code or the state building code. So the genesis of this, and this is near and dear to my heart, I started practice in 1982, and in 1983, I was handed the case of Eddie Markham. Eddie was a single guy who lived in East Hampton, and he had inherited a 3/4 acre lot that originally was granted to his family by the King of England in the 1720s. And Eddie wanted to build an 800 square foot home. And the town regulations said for that zone, no, you got to build at least 1,200. And Eddie Markham said, well, I don't need 1,200. It's going to add 40% to my building cost. And there's really no basis for it. The town denied a permit. We went to the state Supreme Court, which said that the 1,200 square foot minimum was an exclusionary zoning rule that had served no legitimate zoning purpose. And I'm very proud of this case because as a young lawyer, I argued this in front of the Connecticut Supreme Court in 1987, and we got the decision in 1988. And by the way, Builders Service Corp, for those of you who go way back, was an affiliate of the Home Builders, and it was administered by Dick Davis, who was Jim Paris's predecessor Bill Ethier's predecessor going back those years. Just to finish the story on Builder Service, the legislature took note of that case, and that led directly to the enactment of 830G. But back to minimum floor area. The decision has been largely ignored over the years since 1988, but now finally we have a legislative response that basically says that no zoning regulation can require as a minimum floor area more than the health code or the building code. Well, we checked, there is no minimum in the health code, and in the international residential code, it says 120 square feet minimum for a habitable room, 70 square feet for each additional room. And that's really the only standard regarding floor area. So long story short, any minimum floor area for a residential unit that is on the order of 400 square feet or more is now going to be vulnerable and should be repealed. So again, you as builders have now gained more ability to create greater density and do more with the land that you own or have under option. So I think these first two things are kind of a big deal. Okay, now let me move on, and I'm going to buzz quickly through a number of other things. Peer review fees. Andre, if we can have the next slide. There we go. So I'm sure many of you have been subjected to this abuse. The state law for many years has said commissions may charge reasonable fees, but we've seen over and over again peer review fees, excessive fees, a charge for work that is actually done by a salaried town employee. So the town isn't theoretically incurring any extra cost. A requirement that you put down 150% of the expected costs, basically writing a blank check to the town, delays in returning unused funds, and really not adopting the sensible reforms that were written into the incentive housing program of about 12, 14 years ago. So the new rule is only reasonable fees associated with a necessary review. The reasonable is still a sort of undefined term, but it's a basis to challenge if you think the fee is excessive. For technical aspects, traffic and stormwater listed as the specific examples. So not things that are sort of out there in the ether, like a character of the town or something like that. The fees have to be accounted for separately, can't be charged if the work is done by a salaried employee, and remaining funds returned with interest within 45 days after completion of the review, not the application, but the review. So that hopefully will save you some money and help you in the development process. Next slide, please. This is not something that comes up a lot, but it is a bad practice that the legislature has now outlawed. There are some towns that limit the multifamily units, duplexes, triplexes, or mixed-use development as a percentage of the total housing units in the town. That's arbitrary, and it is now prohibited. There's a couple towns in Fairfield County that have these caps that the new law outlaws as of October of this year. The next topic is accessory dwelling units. And again, the question is, whether this is going to enable a rapid creation of new accessory dwelling units, sometimes known as granny flats. I don't like that term, but because creating an accessory unit in a single family home or on a single family lot it requires an expense, maintenance. You become a landlord. So who knows how many people will take advantage of, but the idea was to open up this as an avenue for more affordable housing by making these units as of right, no special permit, no public hearing. They can be attached or detached to the main structure. There's a minimum size up to the greater of 1,000 square feet or 30% of the main dwelling unit. They can't impose additional architectural requirements, no age restrictions, no separate utilities, and may require only 1.0 parking spaces. Okay, now the next one, and this is the real sleeper in the bill. The new act says zoning regulations must affirmatively further the purposes of the Federal Fair Housing Act, quote unquote. It's hard to figure out what the implications are, except to say that they are huge. Connecticut is the first state in the country to have this requirement. The Fair Housing Act prohibits discrimination in housing based on various categories, race, sex, family status, etc. But affirmatively further means an affirmative obligation on the part of the town through its zoning regulations to overcome, to remedy discrimination, segregation, and exclusion. So we could talk about this for hours, but very briefly, in the Clinton and Obama administrations, affirmatively further was understood as if a municipality got, for example, a community development block grant, federal money, CDBG funds, they had a requirement to prepare a so-called analysis of impediments in their zoning regulations to housing opportunity, identifying the populations in the town and in the region that historically have been excluded from housing opportunities, and taking affirmative action, affirmatively furthering action to overcome those barriers. So, long story short, the types of zoning regulations that potentially are vulnerable now based on this provision include large lot zoning, burdensome requirements for multifamily housing as opposed to single family housing. For example, as in Woodbridge, special permit for multifamily, but not for single family. A lack of any regulations promoting affordable housing, occupancy limits, age restrictions, except as allowed by the Federal Fair Housing Act, definitions of family, the number of unrelated individuals who can live together in a unit. The potential for this, using this to overcome exclusion, open up development opportunities is huge. To be determined by applications and commissions in the courts, but keep this in mind because this is a big deal. Okay, other provisions. Next slide, please. The zoning regulations must consider impacts on land uses that are on contiguous municipalities and the planning regions. This is meant to strike at the heart of the status quo, which is we only consider the impacts within the town or within the neighborhood. If you're going to look at traffic impacts or other infrastructure impacts, you need to look beyond the town boundaries. There's another provision that says the regulations must promote efficient review of proposals and applications. Now, next slide. Every good bill has a downside. There is this: zoning regulations shall protect, quote, historic, cultural, tribal, and environmental resources, unquote. No definition of these terms. My concerns are that some zoning commissions are going to say that they now have authority over wetlands, lakes, rivers, streams, Long Island Sound, and the reference to historic. We have a statute about historic preservation, and who knows whether this will create a new and different avenue for people who want to oppose development based on historic grounds. Now, the next one is a little bit technical, but very interesting. The zoning regulations now may, not shall, may require consideration of vehicle miles traveled to assess the impact of development instead of or in addition to level of service. And vehicle miles traveled means if you're proposing a development on a piece of land, how far are the people who are going to live there have to drive to their jobs, to services, to activities, et cetera. So the less VMTs, the better. So this is clearly a statement in favor of things like transit-oriented development. It favors urban development where transportation, might be, public transportation might be available. It might be interpreted as a factor against construction in rural areas. It was pointed out to me that if you have a major traffic generator that goes to OSTA, the Office of State Traffic Administration, you're still going to, the vehicle miles traveled is not applicable there. You're still going to need to do the level of service analysis, but it's an inroad, no pun intended, to assessing traffic impact on a different basis than we have done traditionally. So there are a couple other bells and whistles in the new act, but as I hope you can get from my summary, this is a big deal, and it's going to open up development opportunities that you didn't have before. It's the first real change that we've had in decades. So let me now turn it over to Andrea Gomes, who's going to tell you about the unparalleled excitement of the last couple of days. Andrea?
Thanks, Tim. Good afternoon, everyone. Pleasure to be here. Not quite blockbuster movie level excitement, but finding out that a new law was signed in just a couple days ago certainly kept us on our toes, particularly given today's discussion. So I'm going to be talking about two public acts that were recently enacted and signed by the governor, 2134 and 21163. Both of those amend various laws regarding the effective date and expiration dates of certain land use approvals. So House Bill number 6531 was actually originally introduced regarding only the right to counsel in eviction proceedings. It was later amended to tack on unrelated provisions regarding effective and expiration dates of land use approvals. I mention this only because if you look at the title of the act, it talks about right to counsel in eviction proceedings, which really has nothing to do with what we're discussing here today. So just to be clear that they're unrelated and we're not touching on the eviction proceedings. Public Act 2134, which is what House Bill number 6531 eventually became, was signed by Governor Lamont on June 10th. There's a second bill, House Bill 6541. This was the exciting one, and that was introduced regarding exclusively the extension of certain land use approvals, and that was signed as Public Act 21163 on Monday, July 12th. So taking these two acts together, here is what they did to the different types of land use approvals. First, the acts amended the wetlands statutes and did so in two ways. First, it provides that any wetlands permit issued on or after July 1st, 2021 will have an effective date that coincides with any related necessary planning or zoning approval. That is new. And the public acts also amended the expiration dates. And I'll just give you a little bit of a warning. I'm going to be throwing a lot of dates out there, and they certainly make my eyes cross. So I'm sure they'll make everyone else's eyes cross, but we're really talking about two time frames with all of these amendments. We're talking about approvals approved prior to July 1st, 2011 that have not expired prior to July 12th, 2021. And then the second time frame we'll be talking about throughout today's presentation is permits approved on or after July 1st, 2011, but before June 10th, 2021, which haven't expired as of March 10th, 2020. So if you kind of think about pre-2011, post-2011, that will help things stay a little bit more bifurcated and clear. So with respect to wetlands, the public acts together establish that those approved prior to 2011 will not expire less than 14 years from the date of approval, and that those approved after July 1st, 2011, but again, before June 10th, which haven't expired as of March 10th, 2020, will also not expire less than 14 years from approval. In both cases, the amendments provide that the wetlands permits shall be renewed upon the request of the applicant, unless the agency finds there was a substantial change in circumstances or that there was an enforcement action that had been brought in the interim. And those additional extensions can be up for an additional 5 years for a maximum wetlands permit period of 19 years. So both acts also amended the time to complete work associated with certain site plan and subdivision approvals. So 2163 extended the time for site plans and subdivisions. Again, this is that earlier time frame approved prior to July 1st, 2011 that haven't expired prior to July 12th, 2021. And it did so by providing a minimum of 14 years to complete that work for site plans and subdivisions, with the ability to request an additional 5 years for a maximum approval period of 19 years. Two things to note when comparing these amendments to the amendments to the wetland statute, you'll note that the deadlines are the same. You've got the 14 years with the ability to extend an additional 5, and we'll get to that in just a moment. But you'll also note that the mandatory language that we saw in the wetlands statute, providing that the wetlands agency shall approve an extension unless there is intervening circumstances or there was an enforcement action. We don't have that here. So the additional 5 years of potential approval period is somewhat within the commission's discretion for site plans and subdivisions. 21-163 also tackled large subdivisions of 400 or more units, and those amendments provide that the work associated with those approvals needs to be done within 19 years. There's no ability to extend that time frame. 2134 did essentially the exact same thing, but did so for site plans, subdivisions, and large subdivisions approved on or after July 1st, 2011, but before June 10th, 2021, which haven't expired as of March 10th, 2020. Of particular interest here, though, are the amendments that we found to the special permit statutes, which now, for the first time, provide an explicit time frame for the completion of the work associated with special permits, also known as special exceptions. These acts made these changes with respect to those approvals, again, issued within those 2 timeframes prior to July 1st, 2011, which haven't expired prior to July 12th, 2021, and those approved on or after July 1st, 2011, but before June 10th, 2021, which haven't expired as of March 10th, 2020. I repeat it only because if you do so, it'll help get these dates ingrained in your mind without going a little crazy like I had been trying to do so myself. In both cases, the acts provide that the approvals shall expire not less than 19 years from the approval date. Interestingly, the amended statute also provides just generally that there's an ability to extend special permit approvals to complete the work associated with the approval, but it does so seemingly without time limitation. So that maximum permit period that you saw for wetlands, site plans, and subdivisions was not included in the special permit statute. So again, if your eyes aren't crossed by now, trying to keep all these dates and extension periods straight, let's discuss a little bit why the legislature made these changes. As everyone here likely knows, extending time limits to complete work associated with wetlands, site plan, and subdivision approvals isn't new. The legislature did this in 2009 and again in 2011 in light of the economic recession. Those bills were heavily favored by both sides of the aisle for obvious reasons. I have a quote here in the middle of the slide from testimony provided by Bill Ethier in 2011 regarding the 2011 Public Act 11.5, discussing the reasoning behind or the justification and I think the sound public policy behind the 2011 changes to the statute. And I don't love reading from slides, but I think this is important. So extending land use approvals would prevent the undoing of government approvals and the wholesale abandonment of approved projects and activities due to the present unfavorable economic conditions. And the same reasoning applies here, I think, with Public Act 2134 and 21-163. It's no surprise to anyone that COVID-19 hit Connecticut hard in a variety of ways, including with respect to the economy, and in particular with respect to the land use and development industry. It touched every aspect of it: land use, construction, supply chains, even employment. So the legislature appears to have done here what it did in 2009 and 2011 during the recession, and amended the statutes to give owners and developers just additional time to complete their work so that there's not that loss of investment in time. Even if you don't think about what happened in 2009 and 2011, or you don't dive into the legislative history of these two acts, there's a nod to the pandemic, and that March 10th, 2020 expiration date we saw repeatedly included in the amended statutes coincides with the beginning date of the state of emergency declared by Governor Lamont last year. So What is a bit different about these two acts when compared to those passed in 2009 and 2011 is that they, again, amend the effective date for wetlands approvals, as I said earlier, and or for certain wetlands approvals, and then they add new provisions to the special permit statutes to provide that 19-year window. We think they did so for two reasons. Again, the intent here, I think overall on the legislature's part, was to preserve costly approvals during an economic downturn for the exact same reasons that Bill Ethier put so eloquently in that quote in the earlier slide. We also think that there was an attempt by the legislature to place all land use approvals, or at least those that fell within those two timeframes, on parallel timeframes. I don't think it's a coincidence that we're seeing the same time limits keep popping up, the 14 years and the 19 years with potential ability to extend. This combined with the amendment to the effective date for the wetlands approvals tells us that the General Assembly was interested in making sure that the expiration dates or deadlines for these approvals coincide and run on the same track to the extent possible. These acts, and this is the interesting case that Tim mentioned in his opening, were also enacted with full knowledge of a case that's currently pending in the Connecticut Supreme Court, known as International Investors versus Fairfield Planning and Zoning Commission. We are actually co-counsel with attorney John Fallon on this case, who asked us to step in to assist after the appellate court issued what we'll call an interesting decision, but we'll get to that in just a moment. Before I do, just a little bit of background about the case. We could spend an entire afternoon just combing through the facts and combing through some of the reasoning and the analysis of this case, but suffice it to say, the general idea is that an entity, our client, Fairfield Commons, obtained a special permit and coastal area management site plan approval, which became effective on April 8th, 2009. The relevant zoning regulations in place at that time provided that a special permit use had to be completed within 2 years unless it was extended upon request for an additional 3 years. But after amendments to the site plan statutes in 2009 and again in 2011, extending the expiration dates for site plans and related amendments to the Fairfield zoning regulations, Fairfield Commons approval was extended to April 2018 with the ability to seek additional extensions until April 2023. In April 2018, Fairfield Commons approached the Planning and Zoning Commission seeking an extension and submitting that request to extend its approval to April 2023, but a neighboring property owner, International Investors, appealed, essentially arguing that Fairfield Commons approval had expired long before April 2018 because the various statutory and regulatory amendments that I just referenced here didn't apply. On appeal, the trial court found that special permits and site plans are separate and that therefore the laws regarding the expiration of site plans did not apply to special permits. But the trial court then found that special permits run with the land and thus can't expire. On appeal, the appellate court, and this is that interesting decision, reversed, finding that the Zoning Enabling Act authorizes zoning commissions to impose conditions of approval, limiting the time for the completion of a special permit use. The appellate court also found that the statutes regarding the site plan expirations don't apply to special permits. The reason this case is so interesting is because it takes a well-known land use principle and turns it on its head. That is, we know, and I have always understood that special permits are linked and inseparable. Special permits are a type of land use, whereas site plans are literally the document showing the construction of that use, presumably in compliance with the relevant regulations. The decision, and this is important for any applicant, renders the duration of special permits completely unpredictable, sometimes until even after the approval and within the commission's sole discretion. You can just imagine as a developer coming in, spending the time, the effort, the significant expense to get a special permit approval, only to find out while the commission's deliberating that they'll be imposing a year or two to construct the use. The commission might also decide that 1 year is appropriate for your approval as opposed to 5 for another. And there'd be no predictability on how that would occur town to town in light of the appellate court decision. The appellate court decision also creates confusion and an invitation for mischief. If you have 14 or 19 years to complete your work on a site plan, but then you only have 2 years to construct a special permit use, which date applies? What clock is ticking? And the invitation for mischief, clearly, as I'm sure we can all imagine, that will come in with potentially controversial land use applications, such as applications for affordable housing. On appeal to the Supreme Court then, which is again what we are working on right now, the primary issue is going to be whether the Zoning Enabling Act actually authorizes zoning commissions to impose conditions on special permits, limiting the time within which they should be constructed. So how do these two public acts, 2134 and 21163, intersect with international investors? Do they conflict? How do they impact our case? So we understand that at least part of the motivation in passing these two acts was to address the confusion caused by international investors. The acts miss the mark in some ways. For example, they fail to acknowledge that site plans and special permits are linked and should run on parallel timeframes. The acts do, however, show an intent on the legislature's part to create a predictable, statewide, uniform rule regarding the expiration of land use approvals, including special permits, instead of leaving those time limits up to a commission to determine on an application by application basis. Again, the acts, going back to the consistent dates we're seeing, the 14 years and the 19 years that we saw throughout the amendments, the acts impose time limits in line with the maximum time limits for site plans and special permits, which does in a way recognize there is at least some recognition that site plans and special permits are related. And lastly, the acts appear to dismiss the appellate court's concern regarding long-term impacts of an unrestricted special permit use. So both during the oral argument at the appellate court as well as the appellate court decision, you could see that the appellate court was concerned about unlimited special permit duration. So if I get a crematorium approved today, but decide not to build for whatever reason for 50 years from now, how will that use impact the surrounding area in 50 years? The General Assembly's imposition of a time frame of 19 years on special permits, but that unlimited ability to extend the special permit approval seems to indicate to us that the long-term impacts concern is really a non-issue. So with that, I'll thank everyone for their time. I hope everyone's still awake after all those dates and numbers, but I'll turn it over to my colleague, Leah.
Thanks, Andrea. I will be discussing the new rules and procedure for in-person, electronic, and hybrid meetings. And I do want to leave enough time at the end for questions. So I will zoom through these slides, pun intended there. So effective as of July 1 of this year through April 30th of next year, hearings may be held in person, solely online, or in hybrid fashion, combining both online and in-person capabilities. And ultimately, the agency has the discretion to decide which version they would like to use. And right at the outset, I will note that the bill did not continue a commission or municipality's ability to provide electronic notices on its website in lieu of any requirements that they be published in newspaper. So you may recall throughout the pandemic and under the executive order, it was permissible to post everything online 24 hours ahead of time. This is no longer applicable, and we're going back to pre-executive order pandemic rules. So as of July 1st, any hearing or decision notices that were required to be given by newspaper publication prior to the executive order must again be given by newspaper publication. You could go to the next slide. So additionally, notices for online or hybrid meetings must be posted online at the public agency at least 48 hours in advance. And the notice must be posted in the agency's office and on the website. If it's a state public agency, it has to be posted on the office and in the Secretary of State's website. If it's a political subdivision, in the office of the clerk. And if it's a multi-town district, it must be posted in the office of the clerk of each municipal member. The agenda for an online or hybrid meeting must be posted 24 hours prior to the meeting in the same way that I just described. And the notice and the agenda, they must include instructions to the public on how to attend these, virtual online meetings and how to provide comment or otherwise participate in these meetings. Now, practically speaking, if you think about it, this 48-hour window is going to be probably problematic in some ways for planning and attendance and knowing definitively whether a hearing is in person or 48 hours ahead of time, it's going to be online, particularly if you have experts traveling from out of state. So our recommendation is when you file the application or continuance as it may be, it's helpful to actively express what you prefer as far as, or that you consent to having the hearing online. And in many cases, it's better to actively request this and your preferred method of it being online, and then communicate as the hearing gets closer with the agency or municipality. Next slide. Thank you. So in the event that the hearing is held online, if somebody requests 24 hours ahead of the actual hearing, they must be provided a physical location and electronic equipment to participate with the online meeting. And ultimately, they have to be provided the same opportunities for members, or the members of the public have to be provided with the same opportunities to participate as if the meeting was held in person. However, if connectivity is lost, the meeting is not required to be adjourned. Ultimately, if the quorum of agency members attends by electronic equipment, but they're all attending using the same electronic equipment in the same physical location, then the public must also be permitted to attend that same physical location. Next slide, please. So as I'm sure we've all experienced over the past year, the online meetings, they're not 100% foolproof, and occasionally there are some issues that arise as you're presenting with connectivity or otherwise. So it's advisable really for the municipality or the agency to make an announcement at the outset of the meeting, essentially laying out what the procedures are for the online hearing or the remote hearing, as well as what would happen if there is an event of interruption. Ultimately, if an issue arises while the meeting is going on, the agency may post on its website of the expected time of the meeting resuming, or if it's going to be postponed. And if there are connectivity issues as the meeting is taking place, the meeting doesn't necessarily have to be postponed if a member of the public loses their ability to participate. However, as far as the agency members, if there is a quorum and an agency member loses the connectivity and there's still a quorum after that member loses capability or gets disconnected, the meeting can resume. But if ultimately that member is what makes the quorum, then obviously the meeting has to pause and potentially be postponed until there's a quorum again. Ultimately, these requirements are the responsibility of the agency or the municipality, but unfortunately, it's really prudent for the applicant or the developers or the lawyers to really know these rules in the event that there is some sort of issue or disconnect with the agency or commission. Because as we've learned, if the agency or commission gets it wrong, it may be fatal to the applicant's case. So it's really helpful if everyone understands these rules and at the very beginning of all of these hearings are under the same understanding as far as procedurally how they will operate. Next slide, please. So in the event there is an issue and an electronic meeting loses connection, or the chair determines that there's an unacceptable degradation of the connection, or again, if an agency member that's necessary for the quorum gets disconnected, the agency may, not less than 30 minutes, no more than 2 hours from the time of that interruption, do one of the following. They may resume the meeting in person if a quorum is present, or they may resume the meeting electronically again, if the necessary members to form a quorum are able to get connected again. Next slide, please. As far as voting, when the meeting is held electronically or in a hybrid fashion, the vote must be taken by a roll call unless the vote is unanimous. And the meeting minutes must clearly identify which members of the agency or municipality are in person versus which members have attended electronically. And I'll also note here that it is a requirement that participants, both the agency or commission members, as well as members of the public, make a good faith effort to state their name and title each time before they speak, which obviously is probably very redundant by the end of the hearing, but is really necessary for establishing the record. And by the end, at least everyone will know and recognize your name very well. As I wrap up, and so we can open it up to questions, I'll just say, again, as I'm sure we've all learned over the past year, there are certainly benefits as well as downfalls to the electronic meetings and hearings. And by all means, this technology is not perfect. So there's certainly going to be issues, challenges along the way in the event that municipalities or commissions choose either a hybrid or an electronic means of these hearings. So as I mentioned previously, it's our recommendation really to be proactive, understand the set rules and procedures, and communicate with the municipality or the commission prior to the hearing. So, it's understood how members are going to be participating, when you get documents in, how notice is going to be posted. And then my final point I'll just make is, as part of the bill, the language of the bill, the Advisory Committee of Intergovernmental Relations is going to do a study, first to study the implementation of the bill's remote meeting provisions, and secondly, the feasibility of these remote participation capabilities and voting during the meetings. And the final report, which is due February 1st of 2022, which is obviously advanced before the sunset provision of these procedures and rules. It will ultimately include findings of any challenges that were encountered and best practice recommendations for implementing the remote participation aspect, presumably to assess the feasibility of these remote and online hearings on a more long-term basis. So with that, I will conclude and we can open it up for questions.
Thank you. We have a couple questions which we'll get to in a moment, but if you have additional questions, put them in the Q&A or the chat. I will monitor both. Let me just make a couple points of emphasis on what you just heard. In terms of what Andrea was talking about, remember, you still have to make a timely request for renewal. You can't let the permit expire and then think that the new legislation helps you exhume or rejuvenate an expired permit. You still have to make a timely application. Remember that if you have a permit that is appealed, while the matter is in court, the clock is not running. So you could get in Fairfield Commons, the investors case that Andrea talked about, the permit was granted in 2006 initially, but there was 3 years of litigation. So the start date for all the permits was 2009 when the litigation concluded. So keep that in mind. Also keep in mind that for the stuff that I was talking about, the effective date is October. But for the things that Leah just talked about, those are already in effect. The rules about meetings and online and losing connectivity and all that other stuff. Lastly, I want to underscore what Leah said. This 48-hour rule that the commissions can have discretion to choose the format up to 48 hours is a trap for the unwary. If you are going to be out of state, you have an expert or a person on your team who's going to be out of state, and you think the meeting is going to be online, and in 48 hours they say, no, wait a minute, we changed our mind, it's going to be in person. You're going to have scrambles like that. So as Leah said, we're going to try to actively manage the process and let the commission know we request an online meeting and we'd like to get that set up. If you continue the meeting, you start the hearing and continue to another date, nail it down on the record when you're finishing up the first meeting. Don't let it linger until 48 hours before the continuance. Okay. I have a question from Johnny Carrier saying that some of the commissions are already looking at their environmental authority under Public Act 2129. What would that look like? Well, Johnny, the answer is we don't know, but my suspicion is, I mentioned they may gravitate to thinking they now have wetlands authority. If it's not expressly wetlands authority, it's going to be water quality measures, implementing low impact design as an additional set of regulations, air quality regulations, based on things like vehicle miles traveled. So I think they're going to try to create additional permits that deal with, water quality and air quality, and, maybe other, 'cause other environmental resources. Solid waste disposal might be another example, but it is an undefined term in the bill, and, we're just going to have to see how bold some of the commissions are in trying to expand their authority. We have a question from George LaCava. Does any of this affect zoning restrictions on units per acre? Well, not directly, but definitely indirectly. As I mentioned, if you now have limits on parking spaces per residential unit, and a limit on, very low limit on minimum or maximum floor area, minimum floor area, that has got to physically affect the density that you can get on a particular piece of land. So it may be a situation where you had the land and you just couldn't get to the density. Now you can get to the density limit, or it may be that you're going to bump up now against the density limit in the zoning regulations. So that you have to address that on a case by case basis, but affirmatively further the purposes of the Federal Fair Housing Act. That might be used to say, as long as I agree to, an affirmatively furthering fair housing marketing plan, then I should now be able to increase the units per acre that I'm allowed to develop, because I am affirmatively furthering the purposes of the Federal Fair Housing Act. So you see, if you agree to affirmatively further those purposes, then you should be able to get more leeway. And this is not even under 830G. This is a whole new potential for that. You should be able to get greater density because you are going to provide housing that has been denied historically to groups that are protected by the Fair Housing Act. So again, we don't have defined terms, but we have a broad statement of policy and goals. Okay, I'm going to go into the chat room. Vince McDermott asked, in the case of a special development district approved as an amendment to the zoning map that is based on a master plan, with a requirement to subsequently submit a site plan for each phase within a date certain, 5 years, for example, do the new time limits apply, and can the commission have a reverter clause? Well, that's a good question. I think the time limits apply to the entire development, not phases. Second answer, I guess, is that if you have a phasing plan, you should, or if you're intending to take out each phase as a separate site plan or special permission, you should make that clear in your application, so there's no confusion as you're 3 or 4 years into the development. And a reverter clause, again, I think that's the flip side of a phasing plan. Let me, Leah or Andrea, do you have anything to add on my response to that question?
I don't think so. I mean, the phasing issue is interesting because the way that the statute is phrased is from the date of approval. So I guess part of it would depend on how the regulations are written. If each phase is treated as a separate site plan approval, then there could be an argument that the time limits would apply individually. But I think overall it makes more sense to what Tim said, that a phased approval will be looked at as a whole.
We have a question from George Andrews. Do the floor area requirement relaxations translate to neighborhood covenants applied by the developer for minimum floor area requirements? Good question. The new legislation only applies to zoning regulations. So the question would be whether, if you had a restrictive covenant in a development that provided for higher minimum floor area regulations, would that be valid? I would argue it isn't, because you would be, if it's prohibited for the zoning regulations, it's hard to see how it would be valid to have a internal neighborhood covenant that contradicted the zoning regulations. But having said that, I recognize there are some instances where private developers, as long as they otherwise meet the zoning regulations, can have special rules for their own internal development. So I guess I'll answer that with a maybe, George, and I'll give that some more thought. Mark Nizzolo, can you expound on the accessory dwelling units as a matter of right? The intent is to do away with allowing special permits only by special permit or special exception, or really treating them any different than an as of right single family home approval. The legislature ultimately was concerned that we just want to pave the way. If you propose an accessory dwelling unit that meets the standards of the new legislation, you do your plan, you walk into town hall, and you should walk out with a permit to do it without having to go through the zoning commission. Somebody named Ugaldi. I think he's a big player in home building. Hi, Greg. What do you see as the next legislative steps that will be taken? Well, there are so many changes and undefined terms in the new legislation that there's ultimately the next year there's going to be a rush to point out problems, oversights, unresolved issues in what we just talked about. And I think there will be fixes certainly in the next legislative session. Leah mentioned on the new rules for meetings that the rules only go out to April of next year. So there's already a group in place that's going to come up with a further refined set of provisions on those meeting rules. So that's already in place. All right, let me stop there and just ask Andrea or Leah, anything you want to add to what I said trying to buzz through those questions before we run out of time?
I'll just add that I think that next legislative steps will be some type of reaction to whatever the Supreme Court holds in international investors.
Right.
Yeah. So however the Supreme Court comes down on that issue, primarily the Zoning Enabling Act authority issue, whether commissions have the ability to condition timeframes for special permits. I think we're going to see some type of reaction to that because, again, the public acts, I think, try to remedy some of that confusion, but just miss the mark a little bit. They're not quite in line with what is at issue in international investors. So I think there'll be a reaction to that.
Leah, let me put you on the spot for just a second. Loss of connectivity. Is that, what do you think that means?
I mean, ultimately, it does come down to the chair's discretion. So if at a certain point, it's freezing, and again, it's not the members of the public. It comes down to the members of the agency or commission. Right. But if a commissioner gets disconnected and doesn't get reconnected, or there's just an issue with delay, or there's anything that ultimately it's not like a live time meeting at the chair's discretion, they can postpone or completely reschedule.
Yeah, that's a good point. So it could be audio, it could be video, it could be a combination. It also could be some, static on the line that makes it inaudible. It is the chairs. The chairs have a lot of discretion under the new rules. One of the things that I advocated to the Bar Association and the planners is we should all develop a single script that every land use agency chair should read at the start of the hearing. So we have a uniform state rule and understanding as to what's going to happen if there's interruption in the meeting. Okay, I don't see any more questions. We're at 1 o'clock, which was the promised ending time. Bill and Jim, I'm just going to say thank you. Thank you to Andrea and Leah. I think you can all see why I'm so blessed and confident to have a great team with me here. And Bill and Jim, thanks very much.
Right.
The HBRA.
Great presentation. A whirlwind, to be sure. I feel like I just went down a Disney ride.
Yeah.
But that's fine. We thank all the participants. Appreciate your time, and we'll see you some other time. Good afternoon, everybody.